And with regard to the
What are
expert,
we talking about in terms of the pounds of the beams?
several thousand pounds from what I understand.
The several thousand pounds fell on the plaintiff's neck, right?
It was either that or the pulley system that fell on the plaintiff's neck. I think several thousand pounds would kill him.
Saran TV, Cortland Development. Yes.
May it please the court. Brendan Fitzpatrick, counsel for the appellant, Lion Steel. Your Honors, the mere fact that an incident occurred doesn't support an award of summary judgment under Labor Law Section 240. The mere fact that gravity is implicated somehow tangentially to the happening of an accident does not support an award.
Tangentially?
Yes, Your Honor.
What was
That's what the Court of Appeals said in Ross.
Right, but what, in this case, what was tangential about the gravity-related nature of the accident?
Your Honor, I'm just repeating what the Court of Appeals said in Ross against.
Yeah, I know, but I'm just asking you, how are you applying what you're repeating to the facts at hand?
Because gravity applies to everything. It applies to us as we sit here today. And the mere fact that gravity is involved.
The question is whether or not gravity acted here. Are you claiming it didn't?
No, gravity always acts, Your Honor. That's the low burden that plaintiffs have in 240 cases. To simply claim that an accident happened and that gravity was involved.
Well, let's talk about your case, right? Because we're talking about huge beams that were being hoisted with a makeshift type of hoist, right?
No, again, plaintiffs can pejoratively call it a makeshift hoist.
What do you call it?
I call it a pulley, a chain block pulley system where
Was
Mr.
it a
Soto.
pulley system that came from, that was manufactured by somebody, or that was made on the job by people at the job?
It was designed before the job, it was used before the job, and it was used after. It was designed, and an engineer looked at it, inspected it.
Is that in the record?
Yes, I believe pages 1,000 to 103 of the record. Mr. Lorenz, who's a professional engineer, he's the only expert in this case. He looked at the design of Mr. Soto from Gold Line, and he said, yes, this chain block pulley system is sufficient. He
wasn't the person who designed it.
Mr. Soto?
The person you're quoting. The person you're quoting isn't the person who designed this system.
Prepared the draft. Mr. Soto prepared the draft of the schematic drawing of the pulley system.
But he said that, and then it broke.
The mere fact that it broke, Your Honor,
but let me just finish the thought about the fact that it broke. I mean, the plaintiff is alleging that parts of the pulley system then hit him on the back, and so it was impelled to do so by the big beam it was carrying. So that's not a gravity-related incident?
And again, Your Honor, everything on a construction site, a trip and fall is
all right, I agree. It has to be a gravity-related incident that 240 sub 1 applies to. Why is it not that?
There has to be a violation and there has to be causation, and we don't have either of those here. What we have is plaintiff claiming the accident happened and gravity is related, so therefore it's 240, and it has to be. This isn't a case where, as this court has held on a couple of occasions, where something broke or something collapsed for no apparent reason. We have the apparent reason. We have the reason that Mr. Lorenz attested without debate that this device was sufficient and proper to use for this task.
Don't we have someone, a supervisor, Contreras, who said when he learned of the accident that he called the Department of Buildings to indicate that this was an unsafe type of work?
Simply because you call the Department of Buildings after an accident, I don't believe implies that there's something.
He considered the welding of the base of a pulley system onto a beam to be dangerous. So it wasn't simply a phone call. The reason was because, based upon his experience and his observations, he considered that the welding of the base of the pulley system onto the beam to be dangerous. And we have the testimony from the plaintiff that the reason that apparently the welding gave way because the middle of the three of the first beams detached, and that's what struck him in the back, or that's what struck him.
Yes, and we also have Mr. Soto, Mr. Bermeo, Mr. Lorenz, all saying the exact opposite. They're saying that there was nothing wrong with this pulley system, not a makeshift pulley
But there
system.
has to be something wrong with the pulley system if it broke. That's what I'm not understanding.
Your Honor, this isn't a case where the pulley system was only able to lift something around 500 pounds. And plaintiff proved that this weighed 2,000 pounds. This is a pulley system that could carry 2,000 pounds.
And that was based,
Not because it broke.
No, Your Honor, because plaintiff, and this is the testimony of Mr. Bermeo, Mr. Soto, and Mr. Lorenz, they said plaintiff exerting so much pressure on the welds, that caused the failure.
He did that at the direction of one of his supervisors.
No, he did that at direction, according to at least plaintiff, because plaintiff said he only took direction from Mr. Bermeo. That's his testimony.
Even if he did that, does that not rise to the level of some sort of comparative fault versus proximate sole cause of his own accident?
Your Honor, I think that at the very least, it's a question of fact for a jury to determine. A jury to determine whether you have an expert saying that this pulley system was completely appropriate for this task. And they had used it in the past, and they had used it in the future, and without ever an incident. And the only difference in this case is plaintiff continuing to exert pressure, and that caused the welds to break.
thank you.
Good afternoon, Your Honors. Renton Prasad for appellants Cortland Development and AB Capstone. May it please the court. The lower court erred in finding a question of fact regarding whether Goal Line is negligent as to my client's contractual indemnification claims. First, case law says, and it's clear they're not required to show,
The plaintiff was your employee, is that correct?
No, Your Honor, plaintiff was Goal Line's employee.
Oh, I'm sorry, I thought you said you represented Go Line. Apologies.
There's no requirement that we prove that Goal Line was negligent. In a case like this, where the only basis for my clients to be liable is through a statutory violation, there's no requirement that we prove that Goal Line was negligent. And even if we were required to prove that Goal Line is negligent, based on the facts of this case, as between my client and Goal Line, there can only be one party that would be negligent. That would be Goal Line. They fabricated the hoist, they transported it to the site, they installed it, and they controlled its use. Additionally, the court decision is inconsistent as to the finding that there's a Labor Law 240 violation, but then finding that there's a question of fact as to whether Goal Line is negligent. If there's a question of fact as to Goal Line's negligence, and it's the only party that controlled the hoist, made it, then there can't be a Labor Law 240 violation, and vice versa. And the anti-subrogation rule does not apply here. This is a case where it's not been established that Goal Line's insurer was covering Goal Line and my clients for the same risks under the same policy. In their tender response,
When you want to impose contractual indemnification on Gold Lion, right?
Correct, Judge.
So that indemnification provision provides, provided that same are caused in whole or part by the willful misconduct, recklessness, bad faith, or negligent acts or omissions of the subcontractor. So how do you get a determination? How do you get summary judgment for indemnification until it's established that Gold Lion was either reckless, acted in bad faith, or negligently?
Judge, if, as the lower court held, there is a Labor Law 240 violation, then only one party can be negligent. That's Goal Line. And in that case, we are entitled to contractual indemnification from Goal Line.
Why is there only one party that could be, but who says that Gold Lion is the one that's negligent?
Judge, Goal Line fabricated the hoist, they transported it to the site, they installed it, they controlled its use. There are no other questions.
Where does AB Capstone, right? That's the general contractor, right?
Correct,
Where
Judge.
do they fit into this? When you say that Gold Line is the only one that could be negligent?
There's no evidence that they had anything to do with the hoist, Judge. All this
Right, but
testimony.
but they're the GC on the job.
Right, their only liability here would be statutory under 240, but the actual actions that would constitute the purported 240 violation would be by goal
I don't know how
line.
you get summary judgment on indemnification where your entitlement to it is dependent upon showing that the indemnitor is negligent, and we haven't had such a finding yet.
You're
Judge,
basically saying that if there's a 240 sub 1, correct me if I'm wrong, but you're saying that if there's a 240 sub 1 finding of liability, that necessarily that means that the actor who provided the safety device was negligent? That's what you're saying?
in this case, Judge, yes.
I don't know if there's a case that says that, though, counsel. I mean, you have a case that says that? Because you know, there are two different theories of liability. Negligence has certain elements, and 240 sub 1 has other elements. And so I don't know if you can make a predicate that way.
241 doesn't require showing negligence.
Yeah.
I understand, Judge, but as to the indemnification clause, we would still, if goal lines, their actions were the cause of the violation, then they owe us contractual
Right, but
indemnification.
the optimal part of what you just said is if, and we don't have an answer to that if yet.
Correct, Judge, but if, based on the lower court finding that there was a violation, then if that upheld, then we're entitled to contractual indemnification.
But not at this time? Because we don't know.
I mean, if the court were to reverse that, then yes, there would be no
I
contractual
don't know that it
indemnification
would
at that
require
time.
reversal, but thank you.
Thank you, Judge.
Good afternoon, Your Honors. May it please the Court, Kenneth Gorman for the plaintiff respondent. This is a classic Labor Law 241 violation. The pulley system failed because it couldn't withstand the stress of lifting a beam that weighed several thousand pounds.
Well,
Not-
they said they have an expert that says that this pulley system was appropriate for the work it was being used for.
Could have been appropriate for the work, but it wasn't safe. It wasn't the safety device that was required for the work. It could have, I mean, the fact that it was able to lift the beams is one thing. The fact that it collapsed and the pulley system fell on plaintiff's neck,
Well, because the plaintiff was using it incorrectly.
Excessive pulling.
that's what they say. But I mean, it's uncontested that Mr. Bermeo, who testified that the plaintiff was excessively pulling it, he also testified that Mr. Budalo, the plaintiff's supervisor or foreman, was instructing him to keep on pulling it.
How would the excessive pulling play into the proximate sole cause of the accident in any event?
It doesn't. I don't think it does. The bottom line is that it failed. It was too heavy. It wasn't sufficient for the job at hand. And with regard to the
What are
expert,
we talking about in terms of the pounds of the beams?
several thousand pounds from what I understand. And I'd just like to refer the court to Zimmer versus
And the
Chim.
several thousand pounds fell on the plaintiff's neck, right?
It was either that or the pulley system that fell on the plaintiff's neck. I think several thousand pounds would have killed him.
And is it your position that this pulley system was makeshift?
It was makeshift. I mean, they made it on the job. It wasn't manufactured by a company. It wasn't on the market. They didn't sell to the public. It was manufactured on the job. The fact that an engineer signed off on it doesn't mean it's sufficient, especially since it broke. I mean, the bottom line is that it broke. Plaintiff isn't responsible for determining the exact cause of the accident, but just want to point out that Jamie Contarina's Capstone supervisor testified at pages 440 to 441 of the record that the pulley system failed because it could not hold the weight of the beam. It was insufficient. This is a clear case of clear violation of Labor Law 241. The plaintiff was properly granted summary judgment. If there's any further questions, I'll rest on my brief. Thank you.
So at this point, all defendants, owners, and general contractors are now guarantors. According to plaintiff, all he has to prove is that the accident happened. That's something, according to him,
Excuse
failed.
me, are you claiming that any of us said that?
No, I'm claiming that plaintiff said that. Plaintiff is claiming that because he says this failed, even though the defendants have presented, or at least my client, has presented evidence that not only was it appropriate, but that it didn't fail, and that it had been successfully used before and it had been successfully used after to not only hold this, but according to Mr. Bermeo, twice the weight of this. But according to plaintiff, all they have to show is that this failed and fell, therefore they get summary judgment.
Well, did it fall?
It fell. There's no debate that it fell, Your
No,
Honor.
it failed.
It did not, Your Honor. Why did it fail? What was the cause? We have grounds to say that it fell and it was caused to fall because of plaintiff's misuse.
What was the evidence presented that the plaintiff misused it, one, and that two, that his alleged misuse led to the to it failing?
Mr. Bermeo testified that his instruction to plaintiff was to hold it in the air so they could actually weld it to the bottom of the ramp. According to Mr. Bermeo, he kept exerting pressure. And according to Mr. Bermeo, and as well as Mr. Soto, and as well as Mr. Lorenz, the professional engineer, they said that force caused the welds to break. Plaintiff may not like it. Plaintiff may now...
So your expert says that the continuing pulling by the plaintiff caused this to fail. Based on what?
He tested because of the excess pressure caused by the pulling that caused this to fail. Now, plaintiff came before you and said this beam weighed several thousand pounds. According to plaintiff...
So my question was, I'm sorry, I'm looking at the expert's report, your expert's report. Where in the report specifically does he talk about the amount of pulling that can be sustained by the hoist, et cetera?
He testified that this beam or this pulley system was sufficient to hold up to 2,000 pounds. According to Mr. Lorenz...
Where does he say in his report that excessive pulling would somehow detract from its ability to hold up to 2,000 pounds?
I believe page 1,002 to 1,003 of the record, he said that that the excessive force caused by plaintiff pulling on it caused the incident, not any failure of the device which was appropriate for the task.
Thank you.